The independence of the Federal Reserve System. In response to the stock market dipping in April, President Trump announced his desire to terminate the U.S. Federal Reserve Chairman Jerome Powell, his own appointee, for not lowering interest rates quickly enough. Powell subsequently stated that he will refuse to resign if Trump asks him to, because what he said is, it's not permitted under law for the president to fire him. In August, President Trump attempted to remove Lisa Cook, a Federal Reserve governor, claiming that she had committed mortgage fraud prior to her taking office in 2022. Subsequently, a U.S. District Court issued a preliminary ruling holding that the president has not identified anything related to Cook's conduct or job performance as a board member that would indicate that she is harming the board or the public interest by executing her duties unfaithfully or ineffectively. In September, the Trump administration then filed an emergency petition with the U.S. Court of Appeals for the District of Columbia, asking the court to lift the lower court's order and allow him to proceed with firing Governor Cook. News agencies have noted that this case will likely end up before the U.S. Supreme Court and has ramifications for the Fed's ability to set interest rates without regard to politicians' wishes. Following the financial panic of 1907, Congress established the Federal Reserve in 1913 to serve as a central authority for managing monetary policy and maintaining financial stability. According to the Board of Governors of the Federal Reserve System, the Federal Reserve System is the central bank of the United States, and it performs 5 general functions to promote the effective operation of the U.S. economy. It conducts the nation's monetary policy to promote maximum employment, stable prices, and moderate long-term interest rates in the U.S. economy. It protects the stability of the financial system and seeks to minimize and contain systematic risks through active monitoring and engaging in the U.S. and abroad. It promotes the safety and soundness of individual financial institutions and monitors their impact on the financial system as a whole. It fosters payment and settlement safety systems and efficiency through services to the banking industry and the U.S. government that facilitate U.S. dollar transactions and payments. And it promotes consumer protection and community development through consumer-focused supervision and examination, research and analysis of emerging consumer issues and trends, community economic development activities, and the administration of consumer laws and regulations. The Federal Reserve Board has maintained a unique and largely unchallenged status as a highly independent agency. As one recent Law Review article explains, the Federal Reserve is the most powerful central bank on earth and arguably the most important independent agency in the United States. The Brookings Institute explains, the Fed can set interest rates without interference from Congress or the White House, even if politicians are unhappy with Fed policy, and even if they say so publicly. This structure mirrors the way central banks operate in nearly all major free market democratic nations. Elected leaders set the bank's mandate, but the banks themselves maintain autonomy to set individual rates to best achieve their mandates. This allows the central bank to increase interest rates when necessary to keep inflation low, even if raising interest rates is politically unpopular. Richard Rohr, Associate Dean for Faculty and Research at North Carolina State University, has explained that throughout its history, the Fed has faced pressure from elected officials, particularly when economic goals conflict with political priorities. In 1951, President Truman encouraged the Fed to keep interest rates low to manage post-war debt, a challenge that eventually led to the Treasury-Fed Accord, which formally established the Fed's operational independence. In the early 1970s, President Nixon pressed Federal Chairman Arthur Burns to maintain low interest rates. Similarly, the Reagan administration pressured the Fed to loosen monetary policy, but the Fed, worried about inflation, refused to make the suggested changes. The president nominates members to the Federal Reserve Board, including a Fed chair and 2 vice chairs, who must be confirmed by the Senate. They then serve 4-year terms. There are also 12 regional Fed banks. The president and Senate have no say in picking presidents of those banks. They are chosen by the private sector boards of directors, subject to the approval of the Fed Board of Governors in Washington. The presidents of the regional Fed banks stand for reappointment every 5 years. In 2019, the Department of Justice's Office of Legal Counsel asserted that the Reserve Bank presidents are subject to plenary removal by the Fed Board of Governors in Washington. However, the Federal Reserve Board has never fired any of the presidents, nor has the DOJ's position ever been tested in court. Under the Federal Reserve Act, the president has the ability to remove Fed governors before their terms expire, but only for cause. This is a vague standard, and no president has ever removed a Fed governor, and the law has never been tested in court. But the Supreme Court has had the opportunity to evaluate similar situations. In 1931, President Herbert Hoover appointed William Humphrey to serve as a commissioner of the Federal Trade Commission, a government agency tasked to enforce antitrust law and promote consumer protection. Humphrey was a conservative Republican, and after the Senate confirmed him, he continued to serve in his position when Franklin D. Roosevelt was elected president. The FTC Act only allowed a president to remove a commissioner for inefficiency, neglect of duty, or malfeasance in office. President Roosevelt asked Humphrey to resign because he wanted to appoint a commissioner who shared his New Deal policies. When Humphrey refused to resign, the president fired him, and a lawsuit was filed against the president over the lost salary. The case made its way to the Supreme Court, and in 1935, in Humphrey's Executor v. U.S., the Supreme Court ruled that President Roosevelt could not fire a member of the Federal Trade Commission solely due to policy disagreements. The court relied on Myers v. U.S., a 1926 case that upheld the authority of the president to remove a postmaster before his term had expired. However, the court distinguished the Myers case. The court noted that the Myers case dealt with the removal of a postmaster, an executive officer restricted to executive functions and charged with no duty at all related to either the legislative or the judicial power. The actual decision in Myers, the court said, finds support in the theory that such an officer is merely one of the units in the executive department and hence inherently subject to the exclusive power of removal by the chief executive whose subordinate he is. That decision goes no farther than to include purely executive officers. The Federal Trade Commission, in contrast, is an administrative body created by Congress to carry into effect legislative policies. The court, in a unanimous decision, concluded that Humphrey's case was different. It held, when Congress provides for the appointment of officers whose functions, like those of the Federal Trade Commissioners, are of legislative and judicial quality, rather than executive, and limits the grounds upon which they may be removed from office, the president has no constitutional power to remove them for reasons other than those so specified. Subsequently, in Weiner v. U.S. in 1958, the Supreme Court held that the president could not remove a member of a regulatory commission unless explicitly authorized by Congress. Weiner was appointed by President Truman and confirmed by the Senate to the War Claims Commission, which was established by Congress to adjudicate claims from internees, prisoners of war, and religious organizations affected by World War II. Subsequently, President Eisenhower removed Commissioner Weiner in an attempt to appoint his own allies to the commission, and Weiner sued. Weiner argued that the president lacked the authority to remove a member of the War Claims Commission before his term concluded, and the Supreme Court agreed. The court referenced the Humphreys executor case, holding that Congress did not grant the president the power to remove members of the War Claims Commission without congressional approval because the nature of the commission's duties required independence from executive control. The Trump administration has taken issue with the restrictions the courts have placed on the president's power to remove executive appointees of administrative agencies. On February 12th of 2025, the Solicitor General sent a letter to the Senate Committee on the Judiciary, asserting that for-cause removal provisions that apply to members of multi-member regulatory commissions are unconstitutional. President Trump has fired the Biden-appointed heads of the National Labor Relations Board and the Merit Systems Protection Board, as well as the Director of Government Ethics and the special counsel who oversees the office that investigates whistleblower complaints. The Solicitor General stated that the president should not be forced to delegate his executive power to agency heads who are demonstrably at odds with the administration's policy objectives for a single day, much less for the months that it would likely take for the courts to resolve this litigation. The U.S. District Court for the District of Columbia issued a ruling in March citing to Humphrey's executor against President Trump. The court stated, "The Constitution and case law are clear in allowing Congress to limit the president's removal power and in allowing the courts to enjoin the executive branch from unlawful action. Under our congressional system, such checks, by design, guard against executive overreach and the risk such overreach would pose of autocracy. An American president is not a king, not even an elected one, and his power to remove federal officers and honest civil servants like plaintiff is not absolute, but may be constrained in appropriate circumstances as are present here. The Trump administration filed an emergency application for a stay with the Supreme Court, and the Supreme Court held that because the Constitution vests the executive power in the president, he may remove, without cause, executive officers who exercise that power on his behalf, subject to narrow exceptions recognized by our precedents, and the government was likely to succeed on the merits of its claim that president's executive power allowed him to terminate the members without cause. Following this decision, the University of Missouri Law Review published an analysis in which it stated, the Supreme Court's grant of an emergency stay in Trump versus Wilcox is not merely a procedural action. It is a substantive pronouncement laden with significant implications for the separation of powers and the future of administrative law. Specifically, it argues that the court, in allowing the president to dismiss independent agency officials without cause, exhibits a judicial philosophy geared towards expanding presidential control.